Good morning. Yes, thank you. Yes.
Seek Your Lordship's indulgence in making a mention
Yes.
regarding item number 15 of Part 2.
15 of Part 2.
Yes, my lord.
I don't think so. I'll be taking hearing matters from Part 2 today. Where is Part 2? 15.
15, yes.
Okay, that's an RFA.
Yes.
So, don't want, you want adjournment?
Yes, my lord. We have some personal difficulties on our side, so I have taken the consent from the opposite
Okay.
party.
You are for Mr. A.R. Malhotra?
No, my lord. I'm for the appellant.
Okay.
I'm with Dalrat Feli.
Lian Hirma.
Lian Shime.
Lian Rima.
Yes, my senior.
And you have informed the other side?
Yes, my lord.
So, Miss Yarut Lulrat.
Dalrat Feli.
Yes. Miss Ruth Lalruat Feli, appearing for the appellant, submits that there is some difficulty on the part of the senior counsel, Mr. L.H. Lian Rima, to conduct a case today and has prayed for adjournment. List the matter
After a week.
after a week
Obliged.
on a date to be fixed by the registry.
Daily list for motion, item 1.
Yes. Oh, this is that.
My lord, yes, my
You
lord.
have filed an application under
My lord.
227.
My lord, this is the, after withdrawing the IA, we have filed this WP criminal.
This is the same facts where she is arrested and she is now behind the bars.
My lord,
And the bail application is already heard.
heard already. And
When?
reserved, it was heard on 14 July,
14 July.
my lord.
And today is?
Today is 7
Oh,
August.
so I think in Satender Until's case, it is said that within 2 weeks or 1 week's bail needs to be disposed of.
Yes, it as in the usual course, usually within 2-3 days at the most, bail order were usually passed. But in rare case, it may take some 1 week or 2 weeks also. But it's already
Half a month,
more than 3, yes,
3 weeks.
3 weeks, 3 weeks already.
So where is your bail application?
my bail application,
This is the mother, right?
yes, this is
Mother
the
of
mother.
the boy.
The mother of, yes, the
Mother-in-law of the complainant. The
my lord, yes, yes,
matlab-
mother-in-law of the complainant.
Now that the
Yes.
marriage doesn't subsist, I believe, I don't know what has been done. Marriage is still valid,
Marriage is still valid.
only that he has married another person in Israel and he is not coming back.
Not coming back, yes.
Allegation is actually against the husband.
Yes, only against the
In
husband.
I have passed that stay order, I think,
Yes, yes. my
and in
lord.
that I have given in details the
Yes,
contents
details
of
was
the
given in the criminal
complainant.
petition already, my lord.
Huh?
Bill, details was already given in the criminal petition, in the first order. My lord, my bail application is at page 34. 34 and Exhibit E.
34. It was filed on same day,
This is- No, my lord.
the day when it was reserved.
The bail order was filed on
The day when the order was reserved.
order was reserved, yes. The bail order was filed on 4th July. 4th July, and hearing was conducted on 14th July.
After 10 days hearing?
After 10
Acha,
days.
Case diary and all were called.
Pardon, my lord?
In between something happened. Case diary and all were called or what?
Not called. Case jury not called. There was nothing done by the trial court. So the hearing was fixed on, hearing was conducted after 10 days, and then after conducting hearing, then the order was reserved.
There
But
is no
still not-
order as such reserving that order.
No.
Any order by the trial court reserving the order? No, no?
There was specific, there was no specific order written like that. It was said that order will be passed. And then
Have you annexed the order sheets? No.
order sheets, no, my lord.
Let me issue notice to the complainant today,
My lord,
because again in her absence. Of course I can, I think in surrender until it is said that High Court can pass orders under 227 directing the
my lord.
lower court to pass orders in bails within a period, reasonable period, even if not time bound.
My
But
lord.
then, yes. But then without hearing her will not be very proper. Let me issue notice.
My lord.
Hmm.
But in the meanwhile, my lord, what I'd like to submit is that if the matter can be taken up as within a short period, like 2-3 days or something like, because we can take steps as per the direction of the court. Because presently the present petitioner, while under judicial custody, is suffering from bleeding nose. She's having a high blood, blood sugar.
And that is for a jail authority to treat her.
Yes.
What is a prayer here? Only for direction.
Only for a direction, yes, my lord. Direction, if direction can be made to pass an order, whether rejected or allowing the bail, at least if direction can be made to pass any order within a specific time frame, my lord. Even if it is rejected, then we can go for bail, for preferring an appeal or something like that, my lord.
There is no purpose. I'll write that the notice, although notice is required, it is not. Okay, I'll dispose it of this matter.
Actually, the direction is to be made to the trial court only, my lord. Though we have written the respondent's name, the only prayer is against the trial court, my lord.
Okay, right. I heard Mr.
F. Lalengliana.
Changtu, Lal Red Fella.
F. Lalengliana, my lord. That, the first name is my junior, my lord.
Okay. So you are F. Lalengliana.
My lord.
Yes, F. Lalengliana. For the petitioner, it's hot. Why? Switch on the fan. Okay. Lalengliana for the petitioner. This is an application under Article 227 of the Constitution of India. uh, 227 of the Constitution India, praying for a direction to the trial court for expeditious disposal of the bail application number, you can sit, number
Numbers.
416 of 20, you can sit,
My lord.
416 of 2025 in connection with the criminal appeal, criminal complaint number 597 of 2024. Because if I issue notice again, one will go, and again the time when the trial court has to pass the order will keep on increasing. So
Yes.
I'll dispose of this matter
My
with a
lord.
consideration that they will
My lord,
they will
yeah, that may be
dispose of-
better, my lord. May be better.
criminal complaint number 597 of 2024. It is the case of the petitioner that that she was arrested. Petitioner is the lady, right? She was
Well-
arrested in pursuance to the complaint filed by the complainant on December 2024 by which the complainant had alleged, by which the complainant had levelled various allegations against the accused person who is the husband of the complainant. In the complaint, it was stated that the accused person married the complainant on 1st of March 2023, and the said marriage was registered under Section 13 of the Special Marriage Act 1954. The marriage was solemnized while the respondent was in Mizoram on a long vacation, and the marriage was also witnessed. And the marriage was also registered in presence of 3 witnesses, and a marriage certificate was issued. However, the complainant stated in the complaint that after 1 week of the marriage, the respondent went back to Israel with a promise that he would come back soon to take the complainant to Israel. But she said that after reaching Israel, respondent went back on his promise and informed the complainant that it was not possible for him to take her to Israel due to some difficulties, and that he advised her to start a business in which he promised to help her, and that in the meantime he would search ways to take her back. The complainant states that on being assured of the promise, she availed a loan of rupees 8 lakhs from Mizoram Rural Bank with interest at the rate of 10% per annum. However, in the month of July 24, the complainant got the knowledge that the respondent, that is her husband, is engaged to be married to another person in Israel. She, being aggrieved, tried to contact the respondent as well as the parents, but it was stated that none of them had divulged the real facts to the complainant, and that on 17 July 2024, the respondent contacted her and expressed his apology and tendered his apology and admitted his guilt, or you make it the respondent admitted his guilt and tendered his apology. Other way out. Tendered his apology and promised her that since the loan amount was availed by her, on his advice, he would keep helping her. The complainant thereafter stated that the respondent subsequently married another lady without nullifying the first marriage with her. She then stated that she tried to contact the family members of the respondent, and the said family members told her to let go the issue by further telling her that she won't get any relief as they had already changed their citizenship. The said complaint, she as such had prayed in the said complaint petition that the respondent may be convicted and sentenced under section 82 of the BNSS, and also for a direction to pay her an amount of rupees 10 lakhs. And also for an order nullifying the marriage, nullifying her marriage with the respondent. It is noticed that the allegations in the said complaint petition were only against the husband. Full stop. The only allegation against the family members of the respondent was only to the effect that first, the family members did not disclose the real facts to the complainant, and secondly, the family members requested her to let go the issue of marriage with the respondent by telling her father further that she won't get any relief from the courts since they have changed their citizenship. Full stop. Further, the allegations are against the family members of the respondent and not specifically against his mother. However, when the mother came to the state of Mizoram, where is a bail petition, you said? Page number?
Bill
Petition?
Bill petition 34.
Yes, 34. Achha, there was an application from the complainant to summon the mother, right?
Oral submission was made, my lord.
Uh-huh.
Oral submission, the submission was made orally before.
Oral submission.
trial, my lord.
In this proceedings of complaint petition.
My lord.
During the proceedings, in respect of the said complaint petition, a submission is made by the complainant to summon the mother of the respondent as well, apart from proceeding against the respondent, that is her husband. And on the said submission, the trial court had issued summons to the petitioner, that is the mother. Am I going fast? Petitioner, to the mother of the respondent. To which the mother, that is the petitioner, did not appear, right? And that is why non-bailable. And after she was arrested. And did not appear, and non-bailable warrant of arrest was issued against the petitioner. And thereafter, with this, thereafter, on the strength of the non-bailable warrant of arrest, the petitioner was arrested on 9/6/2025. And since then, the petitioner is detained in judicial custody. On you said, when did you file the bail application?
4th July. 4th July.
4th July.
My lord.
On 4th July 2025, a bail application was filed by the petitioner before the Court of Judicial Magistrate, First Class, 5, Aizawl District, Aizawl, Mizoram. Aizawl Judicial District, Aizawl, Mizoram. And the said application was heard on 14th July 2025. And the order was reserved. And it is the case of the petitioner that till date the order has not been delivered. It be stated here that as of today, from 14 to today is what date? Today is 7th. So how many days, Mr. Counsel? It will be how many days now?
From
14th of
from
July.
14th of July.
14th of July. Okay, 14th of July, that was a Monday. So 1 week, 2 weeks, 3 weeks.
3 weeks.
More than 3
More than
weeks.
3 weeks, my lord.
as
Almost
stated,
a month.
That more than 3 weeks have elapsed from the date of reserving the order in the said bail application. Satyendra Kumar until, right? In it is held by the Honorable Supreme Court in many decisions. One of them being Satyendra Kumar until versus CBI. I'll give you the citation later, don't have. Until reported in so and so, by which the Honorable Apex Court had directed. Do you have the decision?
My lord,
I think it's somewhere in 29 point, I don't remember.
as of now, my lord, I do not have the
Huh?
I do not have the citation.
Yes, yes.
I think
Apex Court had directed by taking into account the other decisions that high courts may issue directions to subordinate courts and that the bail applications should be disposed of normally within 1 week. The said direction is reproduced below. I'll give you from reproduced below. ... Since it is not 1 week, but more than 3 weeks has elapsed from the date of reserving the order, this court deems it fit that the trial court, that is, the Court of Judicial Magistrate First Class 5, Aizawl Judicial District, Aizawl, Mizoram, should consider disposing of. I have written the word consider because again they will be overburdened. Let's say consider, that will be enough. May consider disposing of the bail application as soon as possible without any unnecessary delay. Full stop. In this petition, although the complainant is made a party respondent, but the instant application is disposed of with the aforesaid directions, in view of the fact that since there has been already a delay in disposing of the bail application by the trial court, which is deprecated by the apex court, issuing notice would further delay the same. Therefore, in the interest of justice, this petition is disposed of with the above directions. Okay? Will do?
Malo, deeply like that.
For admission, item 2.
Item 2, contempt.
May I please, Your Lord? Before my learned friend make his prayer, my Lord, if I make submission, my Lord.
Achha, otherwise, parties are represented.
Yes,
Parties are, respondents are 1 to 6.
1
Now,
to 6.
As per the order of this court 29/5/25, we were allowed to implead respondent number 7, with the Secretary of the Border Management, Ministry of Home Affairs,
New incumbent.
new incumbent. Now,
He is represented.
he is not yet represented, respondent number 7. Respondent 1 to 6 are represented by my
so,
learned friend. Now, at this stage, postal receipt in respect of the respondent number 2 has returned back from the post office.
Respondent number 2.
Seven.
Okay.
Has returned back from the post office. Now, as per usual practice followed by this honorable court, a postal checking may be done in respect of respondent number 7.
What?
Postal checking.
Tracking.
In respect of respondent number 7, whether he has received.
Achha, there is one question here. Whether review petition which was to be filed in Supreme Court, what happened?
So he has to make a prayer, Malcolm.
Huh?
that has been filed and IA has been registered against the condonation of delay, and then probably this will with a returnable date of 4th of September.
Acha, there is a delay in filing review.
Yes. Yes.
Now, I would like to make a submission on, with that regard, my lord. Now, since this case has been pending for about 7 years now,
See?
we have been rendered landless and we have not been paid adequate compensation.
Huh?
Now, this case, initially it starts from the DC. The DC had made an award, and since the respondent has not satisfied the award, we approached this honorable court The single judge of this court has passed an order for payment of compensation. Being aggrieved, the respondent has filed an appeal, which goes before the division bench of this honorable court.
Appeal against the single judge's order?
The division bench order. Now
division bench order.
the division bench order has gone to the Supreme Court, and that Supreme Court has dismissed the SLP. Now against that SLP order, they have filed a review petition. Now I think, my lord, it is my humble prayer that the respondent number 1 to 6 has to be called before this honorable court to submit their point as what is the next step they are going to take.
In fact, on the last occasion, a direction was made for them to give the status report, the
Yes,
latest status
Yes,
towards
Lordship,
compliance.
it is like this.
29.5.
The last paragraph. Meanwhile, if in the event of the review petition being disposed, then against the review petition, the respondents in terms of so-and-so will file a
Acha, there
compliance.
is a rider.
Yes.
Yeah, that's right.
That is
The
why, that is why.
respondents in terms of court's order
Yes.
is to file their affidavit reflecting
In
the
the event
steps
of
taken.
disposal of the review petition.
Acha.
Yes. That is awaited.
That 29.4 order is for appearance of the respondents.
That is why we may await for the outcome of the review.
Now, if you
Because
look-
I have placed that one paper wherein it is
And
written
your
that
appeal is in connection with the assessment of the award or
yes,
what?
it's
Compensation.
Yes.
It's in continuation with this writ petition only.
Okay, what I'll do today is now that the matter is pending before the Supreme Court, and let's see, review will not take long.
Yes.
And in the meantime, 7's postal consignment may be tracked.
Yes, my lord. My lord,
And,
let my learned friend file his affidavit. What happens before the Supreme Court? He has mentioned in the last court date also that they have filed this review petition,
Yes, I have
but
placed
it has
that
not been
paper.
placed before the court by way of affidavit.
No, Your Lordship, that paper has been placed. Now I have the IA number
The
also.
paper has been
Last
placed.
time there was no IA number. Now we have the IA number for condonation of delay. That I have placed now.
The paper has been placed, but it is not under oath. It is not by way of
is
affidavit.
in
We can
connection-
accept that. We can accept.
this one is in connection with the review, right?
Yeah.
In the present petition?
Yes, yes.
They have been given much leeway now, my lord.
Okay, right. Heard Mr. Lal
See the Fakzwala.
C. Lal Fakzwala.
Yes, my lord.
Heard Sri Lal Fakzwala for the petitioners, and petitioners are in number 714.
1 to 7. Petitioners are 713.
Yeah, 14.
Yeah, 714.
And
One.
Mr. Roshan Subedi for the respondents number 1 to 6.
Yes.
You can say that, yes.
It is reflected in the office note dated 12/6/2025. Now, postal receipt received.
No, it's received only from the post office. That we have make use of their service, but
Acha. Yeah, reflected that postal receipt is received from the postal office and was kept in C file in respect of service of notice upon respondent number 7. However, the registry is directed to track the consignment note
yes,
in respect of the said service.
my lord.
Further, Mr. Roshan Subedi has placed that in respect of the review petition filed against the dismissal of the SLP before the apex court, there has been a delay in filing of the said review petition, and an IA is filed for condoning the said delay, and the IA is being numbered as 137846/2025, and the same is under consideration before the apex court. However, C. Lal Fakzwala, appearing for the petitioner, states that Now, it has been 7 years since the order has been passed by the learned single judge. Learned single judge's order, right? They went in appeal to the DB and then
Yes,
to
yes,
Supreme
yes.
Court.
Be dismissed, SLP also.
So, learned single judge's order. And the same has not been complied with. And that in the meantime, the respondents had gone on appeal before the High Court as well as before the Honorable Apex Court. But however, he submits that till date, they have not been able to get any favorable order, and that finally a review petition is filed, which is under consideration. As such, he prays that the respondents may be allowed, may be directed to place on record the status of the legal recourse that they have taken, as well as steps. No, legal recourse. Steps to comply will not come, of course. Legal recourse. Place this matter after 2 weeks.
Well, if I may intervene, with regard to that favorable order,
Mm-hmm.
with regard to that favorable order, my lord, we get that favorable order, but we don't get what the outcome of that favorable order.
They have not got till date to even your appeal is dismissed,
Yes,
your
yes.
SLP is dismissed,
Yes.
now you are before the,
Yes.
in a revision of
We get the
jurisdiction.
favorable order, but we don't get
that-
what the
that-
outcome of that position.
That will be the last recourse.
That last recourse, of course. After that, no way out.
No way.
Because
My lord,
I'm
can
afraid
it
that
be?
my submission may not be correct if I say that we did not get any favorable order.
No, I said he did not get.
Correct.
Yes.
He did not get any favorable. Not
lord,
you. You
my lord.
got favorable
Yes,
order.
yes, it's my favorable order.
My lord, can it be kept it as 3 weeks because we cannot say Supreme Court.
Well,
when
my
it
lord,
will
they
be
have
taken
been
up.
given the premium till date.
I will update, no doubt, I will update, but
I think
keeping
it's
in
fair.
2 weeks will become very,
Okay, after 3 weeks?
yes.
But no, without any further delay.
Yes. The
Because-
update will be there, update will be
My
there.
lord, 2 weeks. 2 weeks should be enough because they have been given
Ultimately,
a,
it will come up, so I have to
And,
update. If
when
it
was
doesn't come
this-
up, then it will
they
become
have
field
been
time.
given a premium till date now. They
And when is this fixed, revision petition?
The returnable date expected is on 4th of September.
Okay, after 2 weeks you say that it
Fourth
has,
of
after
September.
2 weeks let them file their affidavit.
because
also.
they are also
we
not
cannot
getting
file
money.
affidavit until and unless there is any update.
No, let them
In
say.
between,
Let them say that with your lordship
There is
permission,
no,
with due respect.
no
Let
point
them
of
say
filing
that they have filed
affidavit
their
if there is no
petition
update
by
at
way
all.
of affidavit.
That's okay, it's okay. After 3 weeks, okay.
Yes.
You have waited for so long, wait
Yes,
for
yes.
some more
1
time.
week will make no difference. I'm obliged.
Item 3.
Yes, my lord, I have received the written objection filed by the respondent. And this honorable court has already framed substantial question of law. It's already formulated by the order dated 25 March
Yes.
2025. So, my lord, if this second appeal may be admitted and listed for hearing in the usual course, my lord. Now, pleadings have been already completed.
Okay.
My lord,
Ah.
my lord, the substantial question of law is not yet formulated.
But it is
Then-
formulated by the last
No,
order.
it is not, my lord. On 25 March 2023, they proposed another substantial question of law.
Oh, achha.
Then the proposed substantial question of law was already proposed that in para number 13 of the memorandum of appeal. And
No,
again they
what
proposed.
the last order says that had approached with three proposed substantial question of law.
Yes.
So these are the three.
Yes.
The court is of the view that the above three proposed are fit to be formulated and hence they said are formulated.
Yes.
They allowed. The learned counsel is directed to furnish a copy. Where is the question of another substantial question of law? There is no another.
It is
None-
fair.
there- none,
it
my
is-
lord.
It is filed in before giving opportunity of hearing this another proposing the substantial question of law. It is again submitted in another application.
Okay, do it in hearing. I'll fix it up for hearing
My lord.
today, now that it has come up for admission.
Yes.
Or
My
you
lord,
want the
before-
matter to be disposed of in admission stage?
My lord, we have not heard properly regarding the proposed substantial question of law.
On 25 you have heard.
25 days submitted without giving me the copy of the first substantial proposed question of law. Then without giving me any opportunity, without seeing this another substantial another proposed substantial question of law, then it is not, it is very unfair.
This is the affidavit you are talking of, right? Here they have proposed substantial question of law, and on the basis of that, it was formulated, it was accepted rather by the court,
In the last court that
last order.
Exactly, my
And
lord.
you were there for the sole respondent.
Yes, and when this honorable court has formulated that substantial question of law, the instant respondent had been represented, my lord.
This is there.
Her name
Jacinthus Jotan
has been reflected.
Maui. You are
Yes.
just J. Jotan Maui.
yes.
Then you were
In
there.
this respect, in the last court that I asked the court to give me time for submission of the rejoinder affidavit.
Acha.
Affidavit in opposition regarding this another application.
But
Accordingly,
Uh-huh.
I filed the affidavit in opposition. But I have not heard about I have not heard about this paragraph on the date.
is directed
Before
to
hearing properly the formulation, before
What you
hearing the
mean to say
substantial
is-
question of law, how can we pursue the case?
Acha, you were not given the memo of appeal before this order was passed.
Memo of appeal was given. A memo of appeal was given. Then after this,
Another.
another substantial question of law was proposed
And
again.
this was not given to you.
Yeah, this was not given to me. And on 25 March 2023, they direct submitted to the court. And without giving me giving me the copy, then they passed this order. And
It's
because
okay,
of
and
that,
then-
because of that, I asked the court to give me for filing the objection. And accordingly, I filed the objection.
My
The
lord.
court has allowed you to file
Yes.
your objection.
My lord,
Yes, my lord.
with regards to the submission made by my learned friend, I have a receipt duly signed by my learned friend,
Yes,
acknowledging that she had received the same.
Yes,
The
yes,
second application,
Yes,
this one.
yes.
yes, I am receiving this application.
That-
Then
that
after that, I
has been
filed
received by
this
the-
objection on 12th day of June 2025.
This has been received by my learned friend on 26th of March. It's reflected.
11th
here.
of March it was filed.
Yes,
11 March they filed, but that
yes,
Received on behalf of the respondent.
yes. So, yeah.
So, okay, you do hearing, you have filed your objection. It will be heard. You will not be prejudiced. So, I'll fix it up. Now that you can keep this.
My lord.
Now that the affidavits are filed,
yes.
and
my lord.
then you want to file any more? Nothing.
I want to file again another affidavit.
Okay. Then, heard Mr.
Tila Zekima, my lord.
T. Lal Zekima for the appellant and Ms. J. Jotan Maui for the sole respondent.
I don't know.
In view of the last order, by which, in view of the, not last order. Yes, in view of the last order dated 12/6/2025, the sole respondents was allowed to file their written objection, and the same was filed on, 12/6/2025, right? 12/6/2025. Miss J. Jothan Maui submits before this court that she has objections in formulating the substantial questions of law in the present case, and she may be allowed further to file objections in respect of the same. Prayer is allowed. List this matter after a period of 2 weeks. Then you file whatever you want to say.
Obliged.
On a date to be fixed by the registry.
Item 4.
There is a mistake here, it seems. Respondent number 4 is already served, but in the last order it shows that respondent number 4 is not served.
My lord, respondent number 4 has been represented and affidavit has been filed. But in their affidavit, they have written as affidavit filed by respondent number 7.
Oh, acha.
So,
I think Mr. H. Gupta, you are there in the matter.
My lord, I am there, my lord.
And he,
My lord,
on the
I
last
could not
occasion
correct
that-
it. My lord, on the last occasion, directed to correct, my lord, my cause title by putting in respondent number, my lord,
4.
7.
Instead
It
of
was
7, 4.
inadvertently written as 7, my lord. I was supposed to replace it by respondent number 4. And my lord, I will correct that, my lord. I pray for some time to correct, my lord. I could not correct it, my lord.
Acha.
My lord
Okay,
has
that was
directed-
actually by respondent number 4.
yes.
So service otherwise is complete on all respondents.
My lord, as per in the last court order, respondent number 6.
was directed.
Service, we have served notice as per the direction of this court on respondent number 6. And it seems that, your lordship, the postal tracking needs to be done.
Is received. Postal receipt in respect
Well,
of
it's only the
R6
receipt.
is received.
It's only the receipt.
Oh,
So ID card has not returned. We have served through Talabana. So ID card has not been returned. Receipt means that it has been sent.
okay.
But
That is what
they
it
have
is
to
meant.
track that whether the respondent number 6 has received it or not.
Must
So
Mr. Gupta, you are not for respondent number 6?
the
My
general
lord,
manager.
I have taken instructions just from, my lord, if they are railway respondents, my lord, I can take notice, my lord, for, I will appear for all, my lord.
Or he is appearing for all?
And
I will appear.
that
So
may be
1 to 7
reflected.
all.
Yes, yes, my lord.
So 1 to 7, acha, these are what, army people?
No, my lord, it's a railway, my lord.
Oh, IRPS.
Railway
Okay.
board and, my lord, the other officers under.
My lord, 2 has been replaced by the new incumbent, that's the 6. So,
Okay, he appears for all.
Appears
So
for all.
notice is deemed to be, is served.
Yes.
Right.
Yes.
And
Only
then,
difficulty, my lord, the cost title has not been amended, my lord. In the order,
Okay.
it is coming up to respondent number 5 only. In the order, last order, order also, my lord, will see that
yes, you
2
will
more
correct
respondents.
it. You will correct it within 7 days time. I'll give you. Okay.
No, my lord, they have to correct it, my lord. The cost title, in the cost title.
we have
it is-
corrected it, it's before the court.
My lord, if my lord sees the last order, which is reflected online also, it is showing only up to respondent number 5. 6 and 7 are not shown, my lord.
No, my lord, if you see the,
Just now I have checked, my lord, I am checking the order dated 10/6/2025. It is showing only up to respondent number 5.
my lord,
No,
respondent
yes.
number 6 is there in the order.
No,
If my
it's
learned
hearing
friend-
that's a respondent
If my
number
learned friend
6.
will read the order,
And 7 also. 6, it is directed, would take steps for service of notice upon 6. So 6, where I will say that the registry to track, or we will wait for some more time. As far as 6. And 7, Dusty is done. So 7 is complete. You
7
are
has
there.
received a notice. That's the-
Okay, you're right. Heard Mr. This is item number 6. No.
4, my lord.
4. Yes, Mr. J.L. Silo, Jonathan Silo, for the petitioners, and Mr. H. Gupta, appearing for all the respondents, that is respondent number 1 to 7.
My lord.
although in
I will
the,
file a formal Vakalatnama, my lord. On instructions, I am appearing today, and I will file the formal Vakalatnama.
who on
Because
instruction,
this is a contempt petition.
who on instruction states that he will be appearing for all. However, he states that he will be filing the Vakalatnama within a short period of time.
No.
So 6, I need not, he is appearing 6, so he has instruction, he will file Vakalatnama.
And it may be reflected that notice has been completed in respect of all
So
the
as far
respondents.
as the notice on the respondents are concerned, it is as such complete, barring the Vakalatnama to be filed by Mr. H. Gupta. On the last occasion, Mr. H. Gupta was directed to correct the cause title of the affidavit that he has filed on behalf of respondent number 4. However, in behalf of respondent number 4. However, the said correction was not made, which was to the effect that the said the affidavit was on behalf of respondent number 4, but it was written as respondent number 7. He is as such given some more time to make the necessary corrections by amending the cause title. Okay, so, okay, fine. Pleadings are complete. No, I think Gupta, you need to file some affidavits on behalf of
For
some.
others also. Yes.
Okay, list it
Others
after
also, yes.
2 weeks. List it after 2 weeks, then he will come up with
Obliged.
the, on a date to be fixed by the registry.
Item 5.
Respondent number 1 has not filed the power, although,
I'm for the respondent number 1, and I filed the Vakalatnama this morning.
okay.
And if the matter may be kindly taken up after 2 weeks.
And my lord, if I may make one small submission, because my lord, I have filed one IA for staying the proceedings of the declaratory suit. My grounds is that.
But then let them file
yes.
Vakalatnama, they will have to reply to your declaratory that
My lord,
okay.
there is, my lord, there is some urgency because the declaratory suit in the trial court is listed for hearing.
When?
Uh,
He will file,
My
he has
lord,
already
my lord.
filed it today, so
Yes.
next week, not 2 weeks,
My lord,
because
my
he's
lord.
saying that the declaratory suit is
Yes.
fixed on a particular date.
My lord,
Yes?
My lord, we have just filed the Vakalatnama, so we need time to go through the IA. So if it taken after 2 weeks, my lord.
2 weeks will be okay,
my lord.
not after that.
Not after that.
The, Mr. Zoram Chana,
Yes.
you are
On
Mr.
behalf of my senior, Zoram Sana.
Your name is?
Samuel Lompuya.
Okay, so and so appearing for Mr.
Zoram Sana.
Zoram Chana, learned counsel for the respondent number 1, right?
Yes, my
Learned
lord.
counsel for respondent number 1 has submitted that he has filed the Vakalatnama only this morning, and he has prayed for some time to go through the appeal. The prayer is allowed. List this matter after 2 weeks. And Mr.
Tila Sakima, my lord.
Yes, he is there for the petitioners, right?
Right.
Deeply obliged.
Item 6.
Yes, show cause reply filed by respondent number 1.
My lord, till that respondent number 2 has not appeared. After that notice was deemed served, the respondent number 2 has not yet appeared.
Respondent number 1 is okay. They have filed their affidavit also.
Yes, my lord. Then I would like to file a rejoinder affidavit.
In response to their affidavit.
Yeah,
And
against
what
the
about the other respondents?
Respondent number 1 is the Kala and respondent number 2 is the railway.
Wait, I'll just see. Okay. Respondent number 1, you are dead. Respondent number 2, there are 5 respondents.
Only 2, my lord.
Hmm?
Only 2.
4. Oh, yes, 2. You are there
Petitioner
for
is
1
five.
and respondent
Petitioner is
number
five.
2, service is not complete.
As far as my knowledge, service is complete.
Complete.
Yes, in the
Respondent number 1. Okay. Must have been reflected also somewhere, no? Okay. So the service is complete. Only that respondent number 2 is yet to file counter, which is not there. And then you need to file reply to the counter.
yes, my lord.
Okay. Then right, in view of the, in response, no, not in response. You say that, yes, in view of the office note dated 11/6/2025, respondent number 1 is represented, and and it is also noticed that respondent number 1 has filed the affidavit in opposition. Show cause reply. Show cause reply. Don't write affidavit. Show cause reply in the said contempt petition. However, your name again I forgot. Jothang Maui prays, appearing for the petitioners, prays that she may be allowed some time to file a reply affidavit to the said show cause reply. Show cause reply by respondent number 1. Prayer is allowed. List this matter after 2 weeks.
Then what about respondent number 2?
Respondent number 2 service is complete, but then none has appeared, right?
Yes, none appear, and my lord,
Let me check
reflecting
the
in the
order sheets.
orders,
Huh?
reflecting the orders is appropriate, I think so.
1 second. Yes. It is also reflected in the office note dated 22/5/2025 that service upon respondent number 2 is complete. But however, there is no representation on behalf of respondent number 2. So this service was complete, what date I said? 22/5. And now they're not much long, so we can await. There can be some representation in near future. Okay?
Okay, my lord.
There is no representation on behalf of so and so.
Much obliged.
Then you write, however, this court deems fit to wait for some more time for necessary representation on behalf of the said respondent number 2. Okay? List it after 2 weeks. If not, then amicus curiae are appointed in civil matters, right? No, we can go ex parte. Yes, okay.
Item 7 for orders.
If I may please, Your Lordship, this is a bail application.
Oh yes, yesterday you mentioned,
yes,
right?
I mentioned it yesterday, my lord. This is a bail application filed under section 483 BNSS, read with section 37 of the NDPS Act.
So he is inside
Yes, my lord, he's inside.
since
Since 23rd May 2023.
23.
Yes, my lord.
So many years.
Yes, my lord.
And trial has started?
Trial has started. Now it's at the stage of defense evidence.
Defense evidence.
Yes, my lord.
This is not a case that where a trial has not proceeded in the manner it should. It is proceeding.
It's proceeding, my lord, but not very fast.
Okay, trial court.
And also,
there
my
are
lord,
cases of Supreme Court where it is said that only 2 witnesses, 1 witness was examined and 2-3 years have gone by. Then in that case, bail is granted. But since prosecution witnesses are over now and they are in the defense stage now, so
that, my lord, our main bail grounds is that they are violations of the mandatory provisions.
Acha, what?
Section 42 and Article 22(1). And also,
Non-serving of grounds,
yes, my lord.
as well as 42, 52, everything.
Yes, my lord.
That will be taken care in the trial. Now the trial is almost over, right? I mean, defense witness, thereafter what? Arguments.
Yes, my
Then,
lord.
judgment.
Arguments and then final arguments and then judgment and order. However, my lord, that there are a lot of cases which is pending in the trial court, and that is why at the last stage also there are a lot of pendency.
But I think
In the trial court.
there are no, well, answer me. There are judgments which says that at the last stage of the trial, bail should not be granted
Yes, Your Lordship,
unless,
I believe that.
of course, exceptional circumstances.
And Your Lordship, if notice may be issued at this stage.
And case diary and the trial court
Yes,
records,
trial court
because
records
we'll have to
be
see
called.
the statement of the witnesses. If no case is made out, then okay.
That, my lord, we have annexed everything. The depositions,
Yes, you have
depositions, yes, and the charge sheet as well.
But then let the trial court records be called for. That would be a better
Yes, my
course.
lord.
Yes, Your Lordship.
Okay, so today only notice and trial court records.
Yes, my lord.
So, right, this is an application filed under
483 BNSS.
filed under 483.
Yes, my lord.
Yes, filed under 483 of the BNSS, read with section 37 of the NDPS Act, praying for release of the applicant on bail. Bail in connection with
SR number
SR number 339 of 2023, along with
arising out of
arising
narcotic PS.
arising out of special narcotic PS case number N-34 of 2023, registered under section 22C of the ND and PS Act 1985. Call for the lower court, trial court records. No, before that. It is stated by Miss, your name please?
Lalngai Sakifanai.
Langai Sana. Okay. Appearing for the petitioner, submits that the petitioner was arrested on which date?
23/5/2023.
23/5/2023, and since then he is incarcerated in the jail, and that it has been now more than 2 years. More than 2 years of the said incarceration. She further states that the trial is on and the defense and the trial is at the defense stage. Ms. Venishami appears for the state of Mizoram. You have given copy. You have copy.
Yes, Your Lordship.
For Mizoram, call for the lower court trial court records and list it after 2 weeks.
Obliged.
For hearing, item 8.